This video will discuss the UK spouse and partner visa route to indefinite leave to remain, otherwise known as ILR, on the 5-year and 10-year routes. As an OISC regulated UK immigration law firm that has helped more than 4,600 partners obtain their UK partner visas, we're very well placed to discuss this. For most applications, indefinite leave to remain, commonly referred to as ILR, can be obtained after 5 years, which is 60 months, of having a partner visa on the 5-year route to indefinite leave to remain. There are numerous caveats to this, which we'll discuss later in this video. For applicants who first applied out of country as a married partner, civil partner, or unmarried partner, this typically involves the first out of country partner visa application, which will be granted for 33 months, the first partner visa extension application, which will be valid for a further 30 months, and then, assuming that the first spouse visa application and the first spouse visa extension application was granted under the 5-year route to ILR, the indefinite leave to remain application. For applicants who first applied out of country as a fiancé or proposed civil partner, the route to indefinite leave to remain typically involves the fiancé or proposed civil partnership visa application, the first application as a married or civil partner, the first spouse visa extension application, and then the indefinite leave to remain application. And for applicants who first applied for an in-country application as a married partner, civil partner, or unmarried partner, this typically involves the first partner visa application, the first partner visa extension, and then the indefinite leave to remain application. For all of these typical routes, we've assumed that applications were granted under the 5-year route to ILR, which is most commonly the case. So, as previously mentioned, applicants can normally apply for indefinite leave to remain after 5 years, which is 60 months, with leave as a partner on the 5-year route to indefinite leave to remain. This is the case if 1. The partner visa extension application was submitted on time, 2. The indefinite leave to remain application is submitted on time, and 3. None of the caveats apply. We discussed when to submit each application in detail in our When to Submit a UK Spouse Visa Application and Indefinite Leave to Remain Application YouTube video. In that video, we also discussed the misconception that applicants cannot be absent from the UK for more than 180 days in any 12-month period, and that the 5-year qualifying period does not necessarily require 5 years of physical presence in the UK. So what are the caveats that would mean that the previous partner visa journey to indefinitely to remain will not be applicable? First, the qualifying period resets when there's been a change in sponsor partner. Second, if the applicant switches to a partner visa from a different category, the 5-year period will reset. For example, an applicant was in the UK on a skilled worker visa. After 2 years in the UK on a skilled worker visa, the applicant obtained a UK partner visa on the 5-year route. The start of the 5-year period will reset when the UK partner visa is granted. Third, if the applicant is in the UK on a partner visa granted on the 5-year route and is subsequently granted on the 10-year route, or vice versa, the qualifying period will reset. Therefore, this will substantially increase the number of applications and therefore costs until the applicant can obtain indefinite leave to remain. For example, an applicant made an out-of-country application and was granted 33 months under the 5-year route to ILR. When the time came to apply for an extension, the financial requirement was not met, and the applicant was given a 30-month visa on the 10-year route to ILR. Since being put on the 10-year route resets the qualifying period, the applicant must extend their visa an additional 3 times on the 10-year route until they can apply for ILR. This is significant because if the extension was granted on the 5-year route, the next application would be the indefinite leave to remain application. So when will the 10-year route to ILR be granted instead of the 5-year route? For in-country applications, the 10-year route will be granted if the standard requirements are not met and there is something in the evidence to suggest that it would be unreasonable for a child to leave, or where there are insurmountable obstacles to family life with a partner outside the UK, or if there are exceptional circumstances. For out-of-country applications, the 10-year route will be granted if the standard requirements are not met and there are exceptional circumstances. Exceptional circumstances here are set to a very high standard. It is not sufficient to merely show that one's circumstances are unusual or challenging, or that they almost meet the requirements set by the immigration rules. Essentially, the applicant must demonstrate that if the Home Office denies the application for entry clearance or permission to stay, it would violate their rights under Article 8 of the European Convention of Human Rights, which guarantees the right to private and family life. The law here is relatively complex, and partners who are considering relying on exceptional circumstances should consider legal advice. We discussed the partner visa requirements and the partner visa process in detail on our website, www.migrate.org.uk. If you want us to continue making videos like this, you can let us know by liking the video, subscribing, or leaving a comment. I hope you found this video helpful.